Okay, welcome everybody to the Vocational Science of Freedom Saturday night Civics and Sovereignty class. And tonight we'll be moving on from banks and banking and going into land rights and title. And if you'd like to join in on the Vocational Science of Freedom classes on the Gilded server, you can do so by going to the Vocational Science of Freedom YouTube page and clicking on the About tab and going down and clicking on the link to join the server. And then you'll be prompted when you get there to answer some simple questions, and you want to hit apply up here in the upper left hand corner of the Gilded server. And then once you apply, then I'll let you in, and then you can join in on the classes. So tonight I want to cover a document regarding the Torrens Registry system. Let me blow this up a little bit so people can be able to see it. All right, so without further ado, I'll just get into reading this. Okay, so the Torrens system of land title registration. Conveyancing in England was originally by physical transfer of all the title deeds, including one from the seller to the purchaser. A crude method, again, that's, you can hear it already, a crude method, right? Well, what that used to be called, that crude method, was called livery of season. And what happened was that two people would go on to the actual land, and there was a exchanging of lawful consideration, gold or silver, and then the other would then literally hand the other person a bit of soil or a twig from the land itself, symbolizing the exchange. So that's where the ancient system came from, where they're talking about a crude method. Okay, so but with the advantages of being cheap, safe, and secret, right? Secret, of course, because private transfer of land is something that should be private. It should have no business as far as the government having to have their hand in it, which is of course now what they all have their hand in, because they have literally pledged all of the land to the Federal Reserve System as collateral for the loans that they get from it. And I put a quote under the in the chat here. So Congress quote about bankruptcy and homes. It was the 73rd Congress that said on March 9th, 1933, quote, "The money, Federal Reserve notes, will be worth 100 cents on the dollar because it is backed by the credit of the nation. It will represent a mortgage on all the homes and other property of all the people in the nation. The money so issued will not have one penny of gold coverage behind it because it is really not needed." Well, yeah, it is needed because it's unconstitutional not to have money that's not backed by gold and silver, which is, of course, Article 1, Section 10 of the Constitution. But even that being stated, you can see already what they did here. And of course, this connects into what the state governors did in 33, was they went to D.C. and they literally committed treason against their own state citizens, because what they did was they pledged all of the registered property. And it was more than just land, because by this point, many people had registered their children. So this gets into registering the biological property as well. Of course, that's not what the Torrens Registry system is about. Torrens Registry system is strictly land, but nevertheless, you see the connections here. So, all right, to continue. In the United States, however, it was early replaced by the recording system, under which, now that says recording system, not registry system, right? So there's a huge difference between recording something and registering it, okay? So under which title papers are transcribed at length on the public records of the county in which the land lies, and thereupon become constructive notice of the claims which they represent to all who deal with the property. That's the American system. That's the way it should be done. Today, a new method, that of land title registration, which bears its name of its inventor, Sir Robert Richard Torrens, once Premier and Registrar General of South Australia, bids fair to replace the recording system, and has already been recognized by law in 14 American states. Recognized by law, right? So what they did was they came in with their statutes, acts, ordinances, and codes of Roman civil law to then force people into this land registry system, where you're registering instead of recording. You're literally registering the deed with them. And of course, under Roman civil law, when you register something, you're giving up ownership of it. You have the right to use it. You're then referred to as the usufructuary, but you do not actually hold the title because they're holding the title, which is how they could do what they did in 33. Okay. Now, as a side note, there's a gentleman who I speak to on a fairly regular basis, and he told me this story about how he and his friends, they figured out how the Torrens registry system works. But in short, what he told me is that in the Torrens Act, all of these acts, there is a way out of it. And actually, in this paper farther down, which we'll read tonight, the attorneys actually lie in this paper and say, well, once it's in there, there's no way to get it out. That's absolute total bullshit. That's just the attorney trying to hold everything in their filthy Roman civil law system. So what he did was he said he went down, he figured out exactly how to get out of it. They went down and they talked to the Register of Deeds at the county, and basically they had a meeting with him for like an hour. And then at the end, he said that the Register of Deeds finally threw up his hands and goes, okay, I'll do this. I'll take it off because all I had to do was make sure that you guys knew what you were doing, and you do know what you're doing. Now, that's an interesting admission from a county registrar, saying that they know all of this is going on, but that if you don't come to them exactly the way to get out of it properly, that they won't allow you to do it, which is, of course, the reason why it's so important to learn these things, go through the history, find out how they happened, do your homework, and reverse engineer everything of what they're doing, which is exactly what the Vocational Science of Freedom status docs do in regards to your estate. And we already have a system of declaring, it's called the Declaration of Allodial Lands, and it's something that we developed long before we even got around to even starting the doc set. This was over a decade ago, and what we had figured out was that we could declare the lands to be allodial and then put the Declaration of Allodial Lands as the first thing into the proper land record, meaning into the registrar, not registering the land, but recording the fact that we, as sovereign people, have declared it to be allodial. Because, of course, all lands in America are allodial to begin with. And what they had to do, what the attorney had to do to take it all back was to trick people into registering it. And so the Declaration of Allodial Lands pulls the original land patent, brings it forward. You have to get a survey done, and you want to get the survey done by meets and bounds of just the portion of the original land patent, of the portion of it that's actually yours. You don't want to be going around and claiming anything that's not yours, obviously. And then you record it, and then notice them that you've recorded it and that you acknowledge the land patent and whatever the other deed was, whether it be, you paid it off from the mortgage from the bank, or you bought it directly from someone, wherever the last deed was, you then have to acknowledge the deed. And that was something that was always done in the recording system, which has been part of American jurisprudence because, one, we're sovereign, and two, the lands are allodial. And no, they're not owned by the government. The United States holds lands until we, the people, decide to go and improve them. And there's a whole aspect of adverse possession, which is in this document, which we'll get into. So anyway, I just wanted to kind of put that out as a beginning part to the rest of this before we get into the rest of this document. So, okay, so this guy was from Australia, and so he basically wanted to replace the recording system into a registry system. And then the attorneys made sure that they pushed it through the states. And besides being an almost universal operation in the British colonies, well, surprise, surprise, of course the British colonies are going to want you to register your land, right? So the disadvantages of the recording system lie in the fearfully complicated state of the record title of land, which is frequently conveyed or encumbered, and the constant liability of the owner to suits on both recorded and unrecorded claims. Well, no, there's no disadvantage of it because it's on the public record. When you get one, it's called an abstract. And I don't even know if they do abstracts anymore or if you can even get one created because this filthy Torrens Registry system has been in operation for so long now. But if you can, you absolutely want to get what's called the abstract, which shows you from the beginning, meaning it'll start at the original land patent and it'll bring every single deed and transfer of that land all the way up through so you have a complete record of it. That's what you're supposed to have because that proves who had the title, who passed it on to whom, and did it correctly and then recorded that transfer. Well, the attorneys don't like that because it's the attorneys that actually want to be able to come in and mess around and do the suits to try to claim land from other people. They want to be able to do this without difficulty. Well, if you have the entire abstract, it's a little difficult for them to do that because you say, no, it passed from the original land patent all the way to me. It is now mine. It is now allodial. Okay? So when you read these things, you can feel the intent of the attorney always. Just with that one sentence, you can see it. Okay, so anyway, to continue. The purchaser of realty, to obtain reasonable protection, must procure the services of a searcher to prepare an abstract of all the deeds, mortgages, lists, pendants, and other documents affecting the property recorded in the county courthouse for years back. Well, that's fine, because once you have the abstract, then you have the copy of it. That should be something that should be in your records. And he must also procure an attorney's opinion on the validity of the instruments. That's absolute bullshit. No, if you get an abstract, it's over. That's it. It's title passed from one man or woman to the next, to the next, to the next, in perpetuity. You don't have to procure an attorney's opinion on the validity of those instruments as affecting the legal status of the title. Or he may accept the doubtful security of a warranty deed. Right? So right there, the attorney's saying the doubtful security of a warranty deed. Well, what does everybody have now? Everybody has filthy warranty deeds. They're not holding title. They have a warranty deed, which is all a warranty deed is the evidence that the title is good, but it's not the title. They've stolen all of the titles in this Torrens Registry system and keep them. And this is something else that a colleague friend of mine ended up finding out when he went down, because he paid for his house. This particular gentleman paid for his house flat out. He had $200,000 or whatever it was, and he paid for the house flat out, the whole thing. Never went through a bank, never had a mortgage on it, right? So years later, I come along and I teach him about these things that we're talking about here. And he said, well, I'm going to go ask them where my title is then. Because he said, all I have is a warranty deed. I was like, yeah, that's not title. And so he went down to the county recorder's office, and it was an older woman who had been there from when there was a change that happened around the 70s. I want to say around mid 70s, like maybe 73, something like that, where they changed the way that they were doing things regarding land title. And this, of course, gets into how they're pushing the Torrens Registry system. So anyway, he asked her, he said, where's the title? He said, this is just a warranty deed. I want the title. Where is it? And she said, oh, we keep those in a safe. The county does. In case your house burns down. And he said, no, you don't. That's mine. That's my title. And he's still now in the process of basically beating them over the head to get the title back. Now, he has done his declaration of allodial lands, and it is the first thing that shows up on his land record. However, after going round and round and getting more and more truth out of various different people who eventually started to leak the truth of what's going on, I think what's eventually going to happen with him is that they basically told him that you can file every single year for your homestead exemption and it won't be taxed. But I know he's not gonna stop there because he wants the title, and all of us should have the title. There's absolutely no reason why a corporate government should hold the title to our allodial lands. Period. Full stop. And there has to be a way that we're eventually going to get these back. And if it comes all the way to the point of forming a grand jury in a county and demanding a full accounting of everything that goes on in the Torrens Registry system and putting attorneys, holding their feet to the fire until they scream as to what they're actually doing and how the whole entire system works and how to get out of it, okay, then that'll be the direction that we have to go. But I have accumulated quite a bit of information about this, about what they are doing. And a lot of it is also in the rest of this document. Okay, so with that said, continue. Even the utmost precaution cannot assure him an indefeasible title. Wrong, because he can take the actions necessary to procure an indefeasible title, right? Unsuspected claims such as the dower right of unknown widows may arise to cast a cloud upon it. Well, no. Again, dower rights and everything else like that would be in the abstract if anyone would have come forward to do something or to put a claim down. It would be in the abstract. So again, this is just the attorney trying to sell you on the Torrens Registry system. So the Torrens system of land title registration wholly does away with the accumulation of hoary documents and provides that dedication of one folium of the register to each particular title, on which only one memoranda of valid and existing liens and claims are kept recorded. Okay, so all they're keeping track of in the Torrens Registry system is valid liens and claims kept recorded, because they don't want anyone to actually know all of the history of what a particular piece of land has on it, basically. If you think about it, The Torrens Registry system, all it is a filthy way to occult the land records. It's really what it is. And it says it has been defined as a system of registering, again, registering, not recording deeds and titles, but registering land, which registers title instead of instruments as evidence of title. And I put a note in here, which is exactly what you never want to do. You never want to register the land. When a mortgage debt is paid, the memorial of it is wholly canceled. When the land is conveyed to a new owner, a fresh certificate is issued, and in every case, the person entitled receives a duplicate of the recorded certificate, right? So again, this is just like going to a title company, and when you register your car and you go to the title company and they give you a certificate of title, it's not the title. The title is the MSO, which I think is what the note is here. Yeah, I said, so you never keep the original, much like in your car, you keep the MSO because the MSO is the title. The title to it is the title. If they're giving you a certificate of title, that's not title. All that shows is that you have the right to use it under their direction and under their tax system, because it's always going to be allotted as being under the presumption that it's being used in commerce somehow. So it'll be commercial, or it'll be industrial, or it'll be agricultural. All three of those are ones that they considered that the land is being used in commerce, meaning that you'll at some point in time cross a state line with the commerce that you're creating, which then puts it under the Federal Commerce Clause. Or residential. But again, residential, being a resident, the definition of a resident is one who is there to do business, and when they're done doing business, they'll go back to where they came from. That's entirely different than being lawfully domiciled somewhere. So again, this is the whole entire system is set up to take away absolute title and give you the right of use under Roman civil law instead of allodial title under common law. Okay. So when the original registration under Torrens law is accomplished, notice is given by service and publication to all whom it may concern, and claims not proved within a stated period are barred as by the running of a short statute of limitations. Well, who came up with that? Again, the attorney. This whole thing is, again, the attorney being able to come in there, alter through this Torrens registry system, land titles, and then once the statute of limitations runs out, they're like, oh, you can't do anything now. No, that's not true, because under the common law, there's a whole different set of rights and protections, which is what they want to get rid of, because the Torrens registry system does not go along with common law. It goes along with Roman civil law. So just remember that. And then under the typical Torrens law, to be sure, the state voluntarily maintains an assurance or indemnity fund. Right, meaning an insurance contract. So once you have an insurance contract on land, every single insurance contract is always adjudicated under maritime amnesty law. So what did you just do? You just put your land into the law of the sea, right? You see how sneaky these filthy attorneys are? It's ridiculous. But anyway, okay, supported by fees on registration to reimburse those whose claims were cut off by error, omission, maladministration. Yeah, there's a word, all right. On the part of the registrar, etc. But the registered holder takes free from all such claims, his title being guaranteed indefeasible by the sovereignty, which is the source of all titles. Well, guess what? We're the sovereignty of the nation. That's the point. The attorney is trying to make the corporate state somehow sovereign. They never have been. They never will be. The sovereignty of all the American states is in the people. We're the sovereign, not the state itself. We created the state. We vest them with power to go do things that we don't feel like doing, but that doesn't make them sovereign. So to continue, the introduction of the Torrens system into the United States has been vigorously opposed by title insurance companies, professional searchers, and others who profit by the confusion and uncertainty inseparable from the old methods. Right. Again, they're putting down and saying that the old system was confusing and uncertain. Well, wrong. The old system was concrete and was absolute that you couldn't mess with. So again, listen to the language. At first, the effort of these interests were crowned with success. The first two Torrens laws, the Illinois Act of 1895 and the Ohio Act of 1896, having been held unconstitutional, but later enactments adapted to the particular requirements of our constitutional system and containing all the essential elements of true Torrens law, have repeatedly withstood attack. That's because what they did was they turned it into it being voluntary. So it goes under the aspect of contract. If you enter into a contract, well, you entered into it. But they can't make, and this is the point why they were unconstitutional. And it's up here. I'll read this little part here in a second. But the point is that they can't force you into a contract. So they had to alter the law and make it clear that it was voluntary, right? So here, okay, the Illinois law was held invalid on the ground that it conferred judicial powers on the recorder. The opinion appears to confuse ministerial and judicial acts, for under the law in question, the court had jurisdiction of all controversies. Exactly, because you're supposed to deal with all land controversies in a court of record that proceeds according to the course of the common law. The recorder's power to register automatically being limited to claims not challenged within the time limited. That, again, so they found it unconstitutional based on the fact that you can't create a law and then come along and say, well, if you don't get it in within the statute of limitations, then you have no remedy. Because you can't force me into registering my property, you filthy attorney, right? So that's where they ran into problems, because they tried to make it, the aspect of being mandatory. And people came along and said, no, you can't do that. It said, but later statutes have avoided the difficulty by requiring that of proceedings for initial registration must be conducted by the court, through subsequent proceedings may be carried on by the registrar. The Ohio law was said to take private property without due process of law. Actually, you know what? Hold on. I want to make a note about this right here, about this part. It says, but later statutes have avoided the difficulty by requiring that proceedings for initial registration must be conducted by the court. This is what my friend was talking about. He said, because it's in the law like this, if there was never a court case, never an actual court, meaning a court of record case, initially putting it into the Torrens Registry system, that's the way that you can take it back out. And he said, my friend said, almost none of them did that properly. None of them went through an initial registration to be conducted by a court. That never happened in the vast majority of the land that's in the Torrens Registry system. So he says that's where you attack it. You go in and you say, look, there was never an initial court case to put it into this system. I'm removing it from this system because it violates the law. You can use their own law against them. Because, again, all land issues have to be done in courts of record, proceeding to the course of the common law. And if they do not do that, if the initial title is not placed into court, or put into this system from a court of record, they don't have it. They don't have the power. You can remove it. And that was exactly his point. And now, actually, I think I'm going to send this back to him and highlight this, because I'm sure it'll be something that he'd be interested in reading, even though he was the one that already told me about this. But it says, now I understand what he was talking about when I read this sentence. Okay, so then to continue, it says the Ohio law was said to take private property without due process of law, notice to adverse claimants not being subject to judicial scrutiny. Again, that's the same idea of not being able to take it before a court, a proper court of record. So there you go. Here it is in your face. This is how you get out of it. And again, I'll gather more information from my friend, and we'll do some more classes on it as well. Okay, so let me go back here. Let me reread where we left off. Okay, so later enactments adopted to the particular requirements of our constitutional system and containing all the essential elements of true Torrens law have repeatedly withstood attack. Right, again, like I said, because they made it an aspect of contract. But again, to get it into the Torrens system, it has to go through a court first. If the land was never put through a court to get it into the system, you can remove it from the system. Okay, so all right, so today the principle of land title registration is firmly entrenched, yeah, good word, and has found such favor with the best elements of the legal profession that the American Bar Association has not only put itself on record as favoring the idea, of course they do, but through a special Torrens committee has submitted a model act prepared by, guess who? The Commissioners on Uniform State Laws, which is something that I clearly explained who those people are and where they came from when I did the entire timeline class. I went over in the timeline class everything about what the Commissioners on Uniform State Laws are, where these filthy attorneys come from, what they're trying to do, and why they're trying to do it. Okay, they're trying to take over all state law in the way that they want to see it done to bring in socialism and communism. That's what they're there for. That's what they are. That's their main modus operandi. And clearly, when looking at the Torrens registry system, you can see their intent here. Okay, so the Torrens law may have many features in common. Under all of them, registration of title is optional in the first instance. obviously. But except in Oregon and Nebraska, subsequent withdrawal of the land from registration is not permitted. Untrue. Because again, like I said, none of them ever go through the court procedure properly to put them in there. Now, I suppose if they did have some that were actually put through a court procedure to initially put them into the system, under what they've written, that would hold up or that would apply. However, I'm not subject to Roman civil law, am I? Nope. So, again, you can just pull it right back out with a court of record. If you have a jury that determines it, they can pull it out. Furthermore, I would say that in a certain aspect, it's a violation of corruption of blood because, meaning the acts of those who came before you cannot then be put upon you, type of thing. What corruption of blood really is about, if your father commits a murder, that you're the one that has to suffer the punishment for it. But in the same way, this idea of registering something into a system when we have the right to hold a allodial title can still be pulled back out. And again, that would be something that I think would be a very interesting scenario for a grand jury to get into. And then, and then my note here, this is a blatant lie written by an attorney. In all the Torrens laws, there was a way to get out, which we've already talked about. There always has to be a way out because you can't force someone to register their lands, which is kind of what I just said. So yeah. All right, to continue. The provision for notice to claimants are subsequently similar, consisting generally of personal service where parties can be found in the state by reasonable diligence, mailing to last known place of residence, and in all cases, publication in a newspaper of sufficient local circulation for a period varying in different states. Though in Massachusetts, Hawaii, and the Philippines, publication, mailing, and posting notices of application in a conspicuous place on the land itself are sufficient without even attempting personal service. However, requiring proof of actual notice in proper instances. A decree entered by the court is made binding on all the world, and the registered owner holds free from all claims not noted on his certificate of title, except 1. Liens and claims arising under United States laws, which the state cannot require to be registered. 2. Short-term leases. 3. Taxes or special assessments not had at the date of the certificate. See, that's how they keep doing property tax sales, is this, because they leave themselves this doorway, right? 4. Public highway land duly dedicated, that would be eminent domain. Rights of actions allowed by the act and, in some cases, existing easements, and a few other classes of claims. A decree once entered can be opened only within a short fixed period. Again, you see what they're doing? So they're saying, well, we can put it into our filthy Roman civil law courts and then we can basically lock it up, right? So you can never get out of it again, which is absolute bullshit. Okay, so a decree once entered can open within a short fixed period. Okay. After which it becomes absolute. Again, wrong. That's the attorney trying to lock things up and steal our land. I mean, if there's one, if there was ever a reason to have a revolution, boy, that was it. And I swear to God, it's going to be the reason again, because this is, when you see what they're doing, they're trying to steal all of our land. So what do you do with a common law thief? You kill them. That's what you do. And that's exactly what the revolutionaries did when they had enough of the British. They got to a point where they were done negotiating with them. What did they do after that? They shot them. And this is going to be the direction that this gets to, because you're not going to have sovereign Americans bow down and have their homes taken. People will, that'll be the end of it. I mean, aside from that and food riots, those are the two things that I think might very well set this whole thing off in a way where every single process of which we do here to stop that from happening as best as we can might no longer work, just because of the simple breakdown of the entire system. But again, the reason it's happening is because we are not operating our system correctly as far as grand juries, petite juries, and common law courts of record. We have allowed the attorney, by ignorance and their force, fraud, lies, and coercion, which have clearly been laid out in this document, to steal from us everything, not just land, our children, our property, the land, All of it, including our very republic. So anyway, all right, to get back to this. Okay, for the administration of the acts, existing judicial machinery has generally been utilized, though Massachusetts has for nearly 20 years maintained a special land court. Right, because there should be a special land court because, again, it needs to be done in a court of record. Okay, with regard to the assurance fund provisions, however, there is a considerable divergence among the American acts. The ideal situation is to have the state, which guarantees the title and cuts off claims by constructive notice and an arbitrary period of limitation, also stand ready absolutely to indemnify claimants injured by mistakes of its officers. Okay, that whole sentence right there, I mean, if you, or sorry, the two sentences, if you know what you're reading right there, you can totally tell that this system is about the administration of infants, right? And so that they also do not end up having any liability, right? So the attorney can go off and run around and do what he wants to do and not take any liability for what they're doing because their corporate state is the one that has the insurance policies to absolutely indemnify. And what indemnify means, in case anybody doesn't know, the word indemnify means promise to pay. Okay, to absolutely indemnify claimants injured by mistakes of its officers. Of its officers. What officers? The state officers. Why? Because they're in a system of stealing your land from you. And heaven forbid we actually put the attorney to task and hang all of them for what they're doing. No, the attorney wants you to turn around and get mad at or attack a fiction of law like an idiot instead of going after them for what they're doing. But I digress. All right, to continue. But only half of the states in which the Torrens Acts are in force have adopted this principle. In the others, as well under the Model Act, neither state nor county stand back of the insurance fund, and if the amount accumulated proves insufficient to satisfy judgments, the claimant must be content with collecting principal and interest from money subsequently accruing to the fund. Again, if you're taking a snippet of something from somebody else, you don't have title to your own estate. You're taking a benefit from someone else, right? You can only have you can have your little allowance money. No, forget it. We're going to claim back all of our estates. We're going to claim back all of our lands. We're going to claim back all of our children. And anyone who comes up against us, they're going to get shot lawfully through a grand jury indictment and then through a court of record as common law thieves. End of story. I have no problem building gallows in every single town square all across America to end this filthy Roman civil law system and those who perpetuate it. I have no problem with that at all. And we can totally do it. We can totally do it lawfully by the common law, by the fact of actually exercising our own sovereignty and saying, no, we've had enough of this shit. Everyone who continues to do this, we're going to give you notice. We're going to end it if you keep trying it, or if you try to come upon and try to do a property tax sale to anyone in this county, you're getting arrested. And you're getting arrested as a common law thief. And that's how you're going to be tried. And if you don't think that the colonists were at this point, they were. And that's the reason the severity of particularly quotes from founding fathers, their letters back and forth to each other about what had to happen. There was no gray area there. And there's no gray area here either. So, to continue. Torrens titles, owing to their security and consequently ready marketability, right? Because what is the attorney doing? All the attorney ever does is alter and change the law based upon market conditions. That's it. Tammy Pepperman taught me that a long time ago, and it took me a while to figure out what the hell she was talking about. But now I can see it as plain as day. That's all the attorneys do. They alter the law to how much they can pull out of you, meaning your productive value, how much they can steal from you, or corporations, or anybody else, based on market conditions. Now, what's a good example of a market condition? Well, let's say things like the complete changing of the entire workforce, where Rockefeller and the rest of the moguls that were the robber barons of the Industrial Revolution made sure to promulgate and promote feminism so that they could get all of the women into the workforce as well, instead of having one income that would support a family from the man and having the woman teaching, raising, and instructing the children. You remove the mother as well, and then you throw the children into forced government re-education camps called schools. There's a market condition for you, and that's exactly what I'm talking about. Things like that. Okay, so let me start this sentence again. Torrens titles, owing to their security and consequent ready marketability, are becoming increasingly popular. And it seems only a question of time before registration of title will not only be encouraged by law in all American jurisdictions, but will become so nearly universal that the total abolition of the cumbersome recording system will be seriously contemplated. Right. You hear it? You can hear it in the language. As attorneys, we want this system gone. That's what they're saying. Because we want to steal everything from you, and we want to have a system in place that will totally do it. And they've created it. And they're doing it because you're not paying attention to what they've done and how they're continuing to do it and how to get out of it. Which is, of course, why anyone who's listening to this is here, is to learn how to get out of it, right? So what the attorney is saying means total end of allodial title and total control of all titles registered under the filthy doomsday book of the Khazarian mob, herein referred to as friends of the system, right? When you're talking about the doomsday book, this goes back to William the Conqueror in 1066 AD in England. That's what they had back then. He came in, William the Conqueror was Serpent Seed Line, came in, conquered England, and turned it from allodial title into the Doomsday Book, which is an aspect of, again, Roman civil law registry. That if you didn't have it registered in the Doomsday Book, you couldn't own it. Instead of allodial title being passed from man to man with lawful consideration, having no registry system above him, right? So, to continue, it is admitted, however, that the greater initial cost of the Torrens registration constitutes a serious barrier to its voluntary adoption, which even the tremendously greater cheapness and facility of subsequent transactions do not wholly remove. And on remedying of this and other defects in the administrative provisions of existing laws, the friends of the system would do well to concentrate their efforts. The friends of the system. The attorneys that are trying to steal your land by forcing you into this Torrens registry system. If that's not blatantly obvious enough for you, I don't know what is. You can see how the attorney can't help but just come out of his hubris every once in a while. Well, there you go, right there. So, and that's where this ends. So this goes on to some other aspect of a section out of the law book where this was taken. So, with that, this is the end of this. Now, again, you guys can download it, take a look at it, start looking through these laws, go back and look at particularly the cases in Illinois and Ohio where they found it to be unconstitutional, right? And then find the section in the Torrens law that states that for the initial registration must be conducted by the court. Find that section of the law, and then that's your out. Because as my friend said, none of them do it. Hardly any, he said, any of these titles were ever properly put in by a court proceeding. Almost none of them. So that's how we can get out of it. And it has to be done by the original man or woman. You can't see. Here's the thing: once someone puts it into the Torrens registry system without going through and having the initial registration be conducted by the court, it's automatically fraud from that point on. There's no way they can go back and undo that. You can't. You're done. You're stuck because you never did it properly. So there you go. That's going to be our out, is how to get out of this Torrens registry system. So with that, let me scroll down here. Does anybody have any questions in chat? No? Okay. Does anybody have any other questions regarding land law that they'd like to bring up, or any question about what we covered tonight with this document? No? Everybody's good?
Yeah, Zen, actually, I wanted to mention something if I could.
Sure.
Yeah, that sound volume okay?
Yeah, you sound good to me.
Yeah, that's cool. Well, I would just like to say for my own personal experiences through listening to you and getting a good feel for the teachings that you're providing us, actually to the people, because, for me to really understand what you're talking about, I have to recognize that there are two worlds, two jurisdictions. What I mean by two worlds is people are born of nature.
Right. Yeah, there's substance and there's fiction, exactly. In that argument, you've given this analogy to me before, and it's not incorrect. There's really no place in law, for the exception of a maxim, which, by the way, is actually in the Declaration of Nationality, which is part of one of the Vocational Science of Freedom status docs. If you read the Declaration of Nationality in the maxims, there's one maxim that clearly states what you're talking about. And it says that where truth exists, fiction of law may not exist. And that is exactly what you're getting at. And I totally agree with you. But aside from that maxim, it's really difficult to find it anywhere explained in law because the attorney does not want you to know that.
And thinking back, I was working on my birth certificate claim and the claim of the estate, claim of title.
Mm-hmm.
And there was that same maxim of law that was in there. And so I recognize that, again, two worlds, two jurisdictions. You got the world of the supreme law of the land, the living, breathing people born of creation and nature. And then we're sucked in to this commercial world.
Yep.
And, right after we're born, they sign us as a registered property of the state. And then the state is actually saying, hey, we're doing a good job. We're protecting these young human guys that really don't know that there's two worlds. And when they come of age and recognize, hey, I belong in commerce, I have no contract, I'm part of the world of the living. And when they come of age and say, hey, I recognize that I'm part of this world of creation.
Yeah, exactly. Right. Because we do live in a secular system of law where anyone can have whatever religious belief they want to, which is perfectly fine. But that under the common law, the law of the land, we all have an agreement and understanding as to what is natural law. And basically what it breaks down to is just simply do not steal. Because every crime under natural law and the common law is an aspect of theft, for the exception of upholding all lawful contracts. Like if you don't uphold a lawful contract that you willfully entered into and know that you entered into it, then but even that is a form of theft in of itself as well. So basically it all breaks down to, on the natural law side, common law side, do not steal. And then on the fictional side, it's do not do what we tell you not to do because we said so, because you've consented, basically. So
it plays into exactly what I'm alluding to, right?
Mm, yep.
Because if you think about how we're sucked into this commerce and now we're property or basically being administered by corporations and government and commerce and commercial law, because we haven't come of age, so they're administering us and they're saying, hey, if you steal, then we're going to fine you or we're going to put you in prison because you haven't learned not to.
Yeah, exactly. Karma, the real definition of karma, it simply means you're doing. That's what karma means. It means you're doing whatever you've done. And there's a quote from JFK in which he said, an error does not become a mistake until you refuse to correct it. And that's always sat with me. I mean, I've kept that quote in my head ever since I first heard him say it. And I thought, you know what? Yeah, that's the point. It's our responsibility to correct mistakes that either the attorneys made or, that we've made by entering into these things, which is, of course, what the doc set's all about. Then we have to do that, because not to do it is also our doing by not doing. You could not do something and then have bad things happen to you because you did not take care of it. That, again, is your karma. That, again, is your doing. You're just not fixing what needs to be fixed. So yeah, and all of that is what needs to be taught to people so that they understand that there is a way out, that they can act, and so that they can have, proper doing, proper karma.
Yeah, I didn't want to go on too long. Recognize, hey, I'm up here in the land of the living. Man, I breathe and exist because of this world of creation, this nature. And for us to really know that and understand that, the answer is actually that we have to get ourselves out of the commercial world. And your process, your paperwork, your knowledge, your education through this paperwork, the words that you use, the maxims of law, all of that is understood when you recognize where you're at in the world of the living and trying to escape the world of commerce.
Yeah, because there's another phrase or another quote. I can't for the life of me off the top of my head remember who said it, but there is a quote that says, "None are more hopelessly enslaved than those who falsely believe that they are free." And I think that was Goethe who said that, I think, who is, I believe, a German philosopher. And he's right, because if you think that having all these licenses and having a social security number and bank account and all these other things, and then when you think you're free, you are hopelessly enslaved because you don't even know that there's a system of slavery around you. That's the most dangerous place to be in. It's also the most self-defeating place to be in, because if you can't wake up to any part of this system being evil and understanding it for the evil that it is, there really isn't a whole lot that anybody can do to help someone like that, which is why I do not focus on promoting the vocational science of freedom to the masses. I don't have the time for it. I don't have the patience for it. And honestly, they're not ready. I only want to deal with people that are ready. If you come here and you're not ready, I mean, that's the reason why they have to answer the questions to get into the Gilded server. If you don't answer those questions correctly, you're not getting in here. So that's the way it is.
For me to envision the future of vocational science freedom, we need educators and teachers who know this so we can go out and teach this exact same thing to other people. So when they do come in, hey, I want to know how to be free. I want to learn about notice. How can I claim my estate and say, I've come of age? So I see Zen as one of the most influential educators. But in order to really understand Zen and what he's teaching, and why I think there's not a whole lot of questions, is the people are at, what? And I think what might help get some people out of this is to recognize two worlds.
No, yeah, and I'm completely open with anyone coming up with ideas as far as awakening tools, which is, I guess, the best way to put what you were describing there. But make your own handbill and then go ahead and submit it to me and we can work on it together. I have no problem with that whatsoever. I just want to make sure that when we do finish it, that it's on official VSOF stationery kind of thing in a locked PDF that will look good and will or teach them this exact particular thing that you're getting at, this difference between these two worlds. And I think it's a good idea. I think we can add things like the maxims of law that we were just talking about and anything else that we can show, like, for example, this particular class between allodial title and color of title. The very idea and the very word color, right? The color of title. Okay, I'm going to be going over color of title next Saturday because I have some documents regarding clearly showing what color of title is as far as land is, and color is always fiction. So yeah. Okay, well, if nobody else has anything else, I think I'll conclude this evening. Yeah, so anyway, thanks everybody for coming. And next week we can talk more about color of title and how we can get our lands back as far as the Declaration of Allodial Lands is concerned, and how to get out of the Torrens Registry system as well. So thank everybody for coming tonight. And tonight's been Vocational Science of Freedom Saturday night Civics and Sovereignty class. And now I can turn off the recording and we can talk amongst ourselves.